Very good evening, students. Good evening, everyone. Very good evening, Shivangi and Ladley. I hope everyone is doing fine. Any volunteer, please confirm about the voice and the video. Very good evening, Sammy. Chaliye. Thank you very much for the confirmation. On that note, let's begin with this class. So first of all, I welcome each one of you to my class on the MCQ test of Indian Contract Act, the Specific Relief Act, and the Sale of Goods Act. Let's start with my brief introduction first. My name is Sandeep Khatri. Following are my areas of specialization, as you can see on the screen: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. I've also shared the link of my Telegram channel where you can connect with me and ask your queries related to judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you are not clear with anything, or if you have any questions in your mind, you may please write your questions in the comments and I'll answer accordingly. So I hope you all are ready for the test. Okay. Very good evening, Anomitro. And everyone, those of you who have just joined, please close your books, notes, bare acts, and everything, and eyes on the screen. And here comes the first question. Quasi contracts are situations where, choose the most appropriate option. Students, before writing the answer, please do write the question number numeric 1 and then whatever your answer is, like A, B, C, or D, whatever you want to answer. Okay, top 3 students to answer correctly. There is only one student who has answered correctly, that is Sammy Gill. Students, quasi contract are the situations where law creates obligations for non-contracting party. So A is the correct one. Okay, why B is not the correct answer? Because law creates obligation for breach of contract. There is no contract in quasi contract. So that is why A is the correct answer. Okay, ji. The law creates obligation for non-contracting party. When you will read section 68 till section 72, you will not you will find that all these situations are deals with quasi contracts. Okay, ji. Next, which of the following cases are related to breach of contract? Top 3 students to answer correctly: Anomitro, followed by Shivangi and Ladley. D is the correct answer, which means all these cases are basically, you can say, deals with the concepts related to breach of contract. Hadley versus Baxendale, without any doubt, is a landmark judgment, but these two judgments also deals with this concept only. So the correct answer is D, all of the above. A promises to paint a picture for B. Choose the most appropriate option. Top three students to answer correctly, Anomitro, followed by Ledley and Sammy Gill. Yes, C is the correct answer. Students, when it comes to the performance of contract, there are contracts which may be performed by someone else, but there are some contracts which deals with specific skills, and this is one of those. So the answer is A, must perform personally. So C is basically the correct answer. A put a gun on the head of B to make him sign the contract is. Top three students to answer correctly, Anumitro, Bhumika and Ladley. Students, B is the correct answer, that it is a situation of voidable contract. Why? Because what A is doing to B is basically causing coercion. So there is no free consent, and as per to section number 19, the answer is voidable contract. Contract with minor is dash under section 11. Top three students to answer correctly, Anumitro, Sammy and Bhumika. And I guess everyone's answer is A, that is void ab initio. The answer is correct. Now I have one more additional question in relation to this concept, and that is, students, when it comes to coercion, when it comes to undue influence, fraud, misrepresentation or mistake, in Indian Contract Act, we have specifically written the result, that whether it is going to be voidable contract or whether we are going to treat that as a void agreement, right? When you have a look at section 19 and 19A and so on for section 20 as well, specifically we have written down the consequences, right? But when it comes to contract with minor, can you please specify any particular section where it is written that, sir, if someone is entering into a contract with minor, we are going to treat that as void ab initio or void agreement? Can you please recall any particular section for that? Please answer in the comments. I hope the question is clear. If not, please do write. I'll repeat myself. Okay, I have got one answer from Anomitro that there is no such section. What about others? Okay. Alex 11. Ladley 11. Okay. See, students, when we read section 11, okay, let me tell you this. See, section 11 tells you who are competent to contract. I'm reading section 11 in front of you. Every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Which means under section 11 that this has not been written that if someone enters into a contract with minor, the result is going to be, the consequences are going to be void ab initio. There is no term that has been used like void ab initio or void agreement. Now my question is, so then how you can answer ki when it comes to contract with minor is void ab initio under section 11? Then, Shivangi, completely correct answer that yes, Muhiri Bibi used this term. But now let me answer this, and please everyone listen carefully. See, the first thing first, there is no such section where it is written, okay, that contract with minor is void ab initio. Now coming to the second question. then why it has not been written? Can anyone answer why it has not been written? Anyone? Anometro, completely correct. Yes, from Mohiri BB we have picked up this, that it is going to be treated as void ab initio. Now I am coming to the second part of the question. It has not been written in any section. I have already clarified that. Anometro's answer was correct. Now coming to why. Now I am answering this. Listen this. The reason why we have not mentioned that this is going to be void ab initio, because there are certain exceptions to that. There can be a contract with minor, and if we specifically written down under any particular section, then there is going to be conflicting. That is going to be conflicting. So let me give you one example. If the contract is completely for the benefit of the minor and there is no chance, there is no liability arising out from that contract, then we are going to treat that as a valid contract with a minor. But in a general cases, we will apply section 11 and the answer is going to be void ab initio. And this is the reason that we don't have any specific section for that. Done? I hope it's clear now. Moving to next one. Agreement is made by top 3 students to answer correctly: Anomitro, Semi, and Ladley. And I guess everyone's answer is correct. Yes. Yes. Everyone's answer is correct, students. Agreement is made by parties. And if I change this question, now suppose the question is contract is made by, and you have the same options. Now please do answer again. What is going to be the answer of that question? Contract is made by, and you have the same options. Okay. Top 3 students to answer correctly: Anomitro, Bhumika, and Shivangi. Yes, everyone's answer is correct, students. Agreement is something which is made by the parties, and contract is something which is made by the law. How can we say that? When it comes to proposal, who is going to decide? Who is going to give the proposal? The party is going to decide to whom he is going to give the proposal. Again, the party is going to decide. Acceptance, again on the parties. Consideration, again on the parties. But when it comes to the eligibility criteria, that is of section number 10, and forcibility by law, that is something which is going to be decided by the Indian Contract Act 1872, which is law. Next one. Powell versus Lee 1908 is related with. It's a landmark judgment, landmark case law, Powell versus Lee. This is also known as headmaster case as well. Top 3 students to answer correctly: Anomitro, Ladley, and Shivangi. D is the correct answer. Sammy Gill, please do correct yourself. This does not deal with minor agreement. This is about acceptance. And to be more specific, this deals with the concept of provisional acceptance. And when it comes to the meaning of provisional, the concept of provisional acceptance, it means provisional acceptance is no acceptance. That I guess we do have one more question related to provisional acceptance. So at that point of time, I'm going to go into the details. What is provisional acceptance? And I have a very good example also of that. So moving to forwards. Last time we have discussed this statement: acceptance is to an offer what a lighted matchstick is to train of gunpowder. Said by who has passed this statement? Starting from Anomitro, Ladli, and Shivangi. Everyone's answer is correct. Raja, correct answer. That is B. None other than Anson. Okay, ji. So acceptance is to an offer what a lighted matchstick is to train of gunpowder. Okay, so the basic concept is we cannot undo some things. There are things which we cannot undo, right? So control Z is not something available when it comes to if you have already given your acceptance, that will lead to promise. Okay, and once there is a promise, then it will lead to your agreement and so on your contract. Next one. Provisional acceptance is top 3 students to answer correctly, Anomitro, Ladli, and Shivangi. A is the correct answer. Bhumika, please do correct your answer. A is correct answer. Provisional acceptance is no acceptance. Now let me give you one example which you are not going to forget for the rest of your life. See, when it comes to judicial examination, it has 3 stages. PT examination, mains, followed by your interview. Now coming to, suppose if you have cleared your PT examination, so basically you are now qualified for the mains examination. Now the thing is, can you claim the job of judicial magistrate first class? The answer is no. Just because you have clear PT examination, that doesn't mean that there is an acceptance, right? That is just for your qualifying nature. That is just for qualifying nature so that you can write your mains examination. So provisional acceptance is which is not the final acceptance. So if that is not final acceptance, then even this formula, even this, quotation will not be applied there. Okay. So acceptance is to an offer what a lighted matchstick is to train of gunpowder. This acceptance we are talking about is the final acceptance. And provisional acceptance means the initial acceptance, not the final one. Okay. And it will be dealt as no acceptance. Moving forward. A's dog is lost. He advertises in a newspaper. Anyone who finds the dog will get a reward of rupees 20,000. This advertisement is I have not received correct answer till now. And yes, Alex first one to answer correctly, followed by Anomitro and Sammy. And VR classes A. So the correct answer here is a proposal. See, I don't know why you easily get confused between a proposal and invitation to proposal. See, the thing is, always do remember there is going to be an advertisement. And if the advertisement is, I'm just giving you the formula that you needs to apply. Just keep remembering this formula, the basic formula. And that is, if the advertisement is telling you to do something, okay, then it will fall under proposal. But if the advertisement is giving you just the information, nothing more than that, then you will treat that as an invitation to proposal or invitation to offer. So in this question, anyone who finds the dog will get the reward, which means you have to do something. What you need to do? You have to find the dog. So if it is telling you to do something, then it will fall under proposal. Now, what kind of proposal this is? General offer or specific offer? Yes, please do answer. What kind of offer this is? Anomitro, correct one. This is a general offer. Now, what is the formula for general offer and specific offer? If you don't know from where the acceptance is going to become, then it will be treated as general offer. But when you know कि okay, there is a specific number and that number can be even in thousands or lakhs, that doesn't matter. But if you know that from this particular place or from these particular people, the acceptance is going to become, then we are going to treat that as a specific offer. Certain relations resembling to those created by contract. Which sections we are talking about? Top 3 students to answer correctly: Anumitro, Ladley, and Shivangi. B is the correct answer from section 68 to 72. Now I have certain questions in relation to this concept, and the first one is the most famous question. Quasi-contract. Please do listen the question carefully. Quasi-contract is a contract. Yes or no? I'm repeating myself. Quasi-contract is a contract. Yes or no? Please do answer. Yes or no? Starting from Anumitro, Shivangi, Ladley, and Raja, everyone is writing no except Alex. What about others? Everyone, please do participate. Please do participate. Okay, now I'm answering this first question. Students, quasi-contract is not a contract. Okay? Alex, please do correct your answer. Quasi-contract is not a contract. Now coming to the reasons. Sir, why not a contract? See, first thing first, there is, when it comes to section 68 to 72, there is no section where this term has been used, that is quasi-contract. First thing. Now, when you read the heading of this chapter, it says certain relations resembling. This is not contract. This just resemble to the contract. And there's a difference. Okay? You know, it's like original iPhone and a fake iPhone. So there is iPhone, but the fake iPhone is not the iPhone, right? So same concept apply here as well. So when it comes to certain relations resembling to those created by contract. So resembling here means which is basically that this is not contract. Now coming to the second reasons why it is not a contract. If quasi-contracts are contracts, then there is no need of these sections 68 to 72. There is no need to mention section 68 to 72 if they are going to be treated as a contract. Okay, so first thing first, quasi-contract is not a contract. Now coming to the second question in association with the same concept. Why we call them quasi-contract and not quasi-torts? Anyone in the comments? Why we call them quasi-contract, not quasi-torts? Correct answer, Anumitro. See, when it comes to contract, we are talking about right in personam. When it comes to law of torts, we deal with right in rem. And when you look at this situation from section 68 to 72, there is one thing that is common, and that is all these sections deals with right in personam. That's why we have named them quasi contract, and still they are not the contracts. Next, which case is known as bumper hall pen case? Top three students to answer correctly: Anumitro, Ledley, and Bhumika. B is the correct answer. Harvey versus Fawcett. The concept of novation is under section. Anumitro, Alex, and Bhumika. Correct answer. That is section number 62. Doctrine of frustration. Doctrine of frustration under section. Okay, I have a very interesting question in relation to doctrine of frustration. If you can answer that. Okay, first let me confirm this one. The answer of question number 14. Yes, everyone's answer is correct, starting from Anumitro, Alex, and Shivangi. Everyone's answer is correct that yes, sir, doctrine of frustration is under section 56. Now listen this. My question is, when it comes to the famous statement of, Anson. Okay, let me come to that as well. This one. This statement, acceptance is to an offer what a lighted matchstick is to train of gunpowder. Now my question is whether this concept has any exception in the form of, section 56. Answer in the comments. Whether this concept has any exception in the form of section 56. Yes or no? Yes, section 56 clause 2 I'm talking about. Raman, your answer is yes. Bhumika, please first give me your answer and after that the reason. You are saying it's subsequent impossibility. So your answer is yes or no? Ladley, yes. Anumitro, yes. Bhumika, waiting for your answer. It's yes or no. I have got your reasons. I just want to confirm your answer. Yes or no? Okay, now let me explain this. See, on one hand, we have a statement from the Anson, which basically the conclusion is you cannot undo, right? This is the basically the in the layman's language, if you want to conclude that statement, that is you cannot undo, right? And on the other hand, we have section 56 clause 2. Now my question was whether this concept has any exception in the form of section 56 clause 2. And the answer to that question is no. The answer is no. Now coming to the reasons. Why no? Why no? See, the conclusion of this concept is if there is one party who has made a proposal, okay, and there is another party who has given a valid acceptance, okay, then there is going to be promise. And this promise cannot be changed, okay. And if either party is breaching it, that will be called breach of contract, okay. But now what is happening in 56 clause 2? So in this case we are having a contract. Even under section 56(2) we do have a contract, but that contract becomes void. And the reason is because it becomes void. So this is something which is subsequent impossibility. So in this case also there is a contract, and in this case there is a contractor. So there is no exception working out here. So contract becomes void because of doctrine of frustration, because of the circumstances are such that we cannot perform the contract. So we call that concept contract becomes void. If we are saying section 56 clause 2 is the exception of this concept, it means we are saying ki sir, now that promise we are going backwards, but we are not going backwards. It is still a contract. It does not become void agreement. It just becomes contract becomes void. So the answer is no. I hope you all are clear with this. Done? Next one. Just quickly give me a thumbs up if it's clear to everyone. Okay, next. The display of clothes on mannequin is top 3 students to answer correctly. Bhumika followed by Anomitro and Rami. Everyone's answer is correct. That is D. Invitation to offer. Which is not necessary to form a contract. Top 3 students to answer correctly: Alex, Varun, and Bhumika. And everyone's answer is correct. I guess it's an easy one. That is invitation to offer. Who drafted Indian Contract Act? Yes, who drafted Indian Contract Act? Top 3 students to answer correctly. Anomitro, Ledley, and Shivangi. Students, A is the correct answer. That is Sir James Stephens. One more thing I'm telling you here, the additional fact. Sir James Stephens drafted Indian Contract Act and Indian Evidence Act, both the laws. Okay. And Lord Macaulay, Lord Millett, and Anderson, they all three were the members of First Law Commission who drafted IPC. Okay, ji? Done. So MacLeod as well, one addition. So all four, MacLeod, Macaulay, Millett, and Anderson. These all four, the members of First Law Commission drafted IPC. Sir James Stephens drafted Indian Contract Act and Indian Evidence Act. And Macaulay was the chairman. A sells and delivers goods to B. C afterwards, without consideration, agrees to pay for them in default of B. The agreement of guarantee is only student who has answered correctly is Ledley. And D is the correct answer. Can you give me your reasons? Can you please give me your reasons? I'll be super impressed if you can tell me the exact reason why it has been held void. Why the agreement of guarantee between all of them is void. No, Alex. Please do correct your answer. The correct answer is void agreement. Ledley, waiting for your answer. Without consideration. No, Anomitro. So what do we call that? Rami, you are very, very close to the correct answer. Because he gave guarantee afterwards. So what? Act done prior. You are very, very close. Okay, I'm concluding the answer. Now please listen carefully. See students, when you study the concept of consideration, as per to section 2D, the consideration may be present, past, or future, right? As per to section 2D. But when it comes to contract of guarantee, past consideration is no consideration. Why? Let's take an example. See, suppose there are three parties, okay? The first one is creditor who is giving the money. Second one is principal debtor who is taking the money. And then the third one is surety. Surety is the one who is giving the guarantee. Now, if the creditor has already given the money to the principal debtor, they have already done the contract, and later on they are adding the surety. So which means for surety, the consideration is past consideration. And when it comes to surety, In case of contract of guarantee, past consideration is no consideration. That is why we are going to treat that as a void contract, void agreement for guarantee. I hope it's clear. Then, if you still have any questions, you may ask. Next, the bailment of goods as security for payment of a debt or performance of a promise is called. Top 3 students to answer correctly: Anumitro, Ladley, and Bhumika. Okay. So B is the correct answer. Okay. See, there is only one basic difference between the concept of mortgage and pledge. Okay. When you are giving goods as a, when you are giving movable property as a security for payment of a debt, that will fall under pledge. And when you are giving immovable property for the security of payment of debt, that or performance of a promise, then that is going to be mortgage. So this is the major difference. Mortgage in case of immovable property, pledge in case of movable property. And the purpose of bailment is completely different. Okay, you are giving your goods for some specific purpose. Okay, ji? So that is basically your bailment is. Consideration is necessary for contract of agency. No, yes, discretion of court, none of the above. I have one of the best example for this concept which you all like easily relate with. You know, when it comes to law students, they do internships, and when they do internships, like maximum internships are without pay, but still you can be, the agent of that particular advocate. So the thing is, consideration is not necessary, right? So the answer is no. Okay. So starting from Nawab, Ladley, and Bhumika, everyone's answer is correct. A. Okay, I guess we have already done with this question. It's a repetitive one. Now some questions from the Specific Relief Act. As per section 3, the Specific Relief Act, every duty enforceable by law is called. Okay, top 3 students to answer correctly: Nawab, Bhumika. Okay, Ladley and Raman. Everyone's answer is correct. Alex, Varun, correct answer. That is C, obligation. Students, when you understand the concept of Specific Relief Act in the very introductory lecture, you do understand the importance of this term obligation. Okay, so obligation is a important term here. C, and this term has also been defined in SRA. Who can amend the schedule relating to any category of projects or infrastructure subsectors? Who has the power to amend the schedule relating to any category of projects or infrastructure subsectors? Top 3 students to answer correctly: Bhumika, Nawab, and Ladley. And Raman also correct answer. That is A, the central government. Top 3 students to answer correctly: Nawab, Ladley, and Raman. And yes, enforcing individual civil rights and not for the mere purpose of enforcing a penal law. Correct answer. Then section number 4. Specific Relief Act is substantive law, procedural law, either A or B, none of the above. I have not received the correct answer till now. And yes, Alex, correct answer. Students, please do correct yourself, everyone. Okay. When it comes to the when it comes to the subject Specific Relief Act, we are going to treat that as a procedural law. Now coming to the question, why? Alex, can you please answer why SRA is a procedural law? Okay, let me answer now. Students, I believe to understand this concept of Specific Relief Act, first you have to go through with the Contract Act. Now, when it comes to Contract Act, basically the story of SRA also starts with the Contract Act only. Okay. So the Contract Act is substantive law. Substantive law means the law that gives you the right. So suppose if there is a contract between you and me, then that particular contract is giving you the rights to me and you as well. Okay. And the contract also telling us the duties as well. Okay. Now suppose Sandeep Khatri breaches the contract. Now you may file a suit. And if you are filing a suit under Indian Contract Act, you will get the damages. But what if you want to use Specific Relief Act on that particular contract? It means it's a procedural law. Specific Relief Act is not giving you any rights. Even if you go before 2018 SRA amendment, you will read that the term may has been used. It means it is always it was the discretion of the courts to give you, the specific relief or not. But yes, now as a general rule, after 2018 amendment, the term shall has been given. But still, the Specific Relief Act is not giving you any specific rights. And that is why we are going to treat this as a procedural law. I hope I am clear with this. Done. Ayush, Indian Evidence Act is adjunctive law. Okay. When it comes to procedural law, there are some purely procedural, for example, CRPC and CPC, and then there are adjective laws like Indian Evidence Act. Okay. Next one. No appeal or any order or decree shall be allowed under section. भूमिका, आंसर टू योर क्वेश्चन, यू आर आस्किंग कि अभी लेटेस्ट अमेंडमेंट के अकॉर्डिंग specific relief act is both. See, still even in this situation, even after 2018 amendment, the right lies in the contract, not in the specific relief act. Even if you are, if you are mandating specific relief, that is still part of the procedural law. So SRA itself, specific relief act itself, is not giving you any rights. Okay ji. Nawab, Ladley and Remy, top 3 students to answer correctly. ठीक है जी. So B is the correct answer. That is section number 6. Ayush, there is only one adjective law, that is Indian Evidence Act, which deals with the concept of proof. Okay. Now these are some questions from the Sale of Goods Act, where the price is not determined by the parties to the contract of sale of goods. What price shall be paid by the buyer? So the contract has already taken place, but they have not finalized the price. So what the price is going to be now? Top 3 students to answer correctly, Rami, Ayush and Nawab. Everyone's answer is correct. That is A. The buyer shall pay the seller a reasonable price. When a seller can stop the goods in transit. So this is basically one of the rights of a seller. So when they can use this right. Ayush, the term reasonable has not been defined anywhere. So first the parties will decide the reasonable price, and if the parties are not able to satisfy on a certain reasonable price, then they will move to the court, and the court will determine the reasonable price. Okay. Basically, you can say the reasonable price here means not as much as high that the buyer cannot afford, and not as low that will result into the losses for the seller. Okay. Then the court will determine. Okay, top 3 students to answer correctly, Ladley, Ayush and Nawab. Yes, everyone's answer is correct. That is C. When the buyer of the goods becomes insolvent and the goods are in transit. See, the concept is there's basic common sense. If the goods are already delivered, then obviously you cannot use this to stop the goods in transit. So the goods should be in the transit. Next, when a buyer can sue the seller. Top 3 students to answer correctly. Raman, followed by Ladli and Ayush Nawab. Everyone's answer is correct. D. All of the above. In a contract of sale of goods, the seller is under no duty to reveal unflattering truths about the goods sold. The doctrine is called. The answer lies in unflattering truths, in the term of unflattering truths. Top 3 students to answer correctly. Remy, Nawab, and Ladli. Ayush, everyone's answer is correct. That is one of the most famous and the important doctrine from the Sale of Goods Act. That is caveat emptor, let the buyer beware. So there is a concept called patent defect and latent defect, which is also associated with this question. And when we say unflattering truth, we mean patent defect. Last question, students. A contract of sale may be made. Remy, Nawab, and Ladli. Top 3 students to answer correctly. And that is D. All of the above. A contract of sale may be made by. So this is basically by your express or implied. So the answer is all of the above. Yes, now students, anything which you are not clear with, you may ask. So this is the link of my profile, my Telegram channel, and this is my code Khatri10. Now, anything which you are not clear with, and if it's all done, quickly give me a thumbs up. I'll wrap up the session. Let's crack PCS J with Unacademy. Students, I have also one important information to share with you all. That there are judiciary test series calendar. This is which you can. There is yes. If you are an iconic students, then all these tests are available for you. For plus students, all this, and for the free students also there are 8 tests per month which you can avail. Okay ji. There is a recent batch which has been recently started, Judiciary Core Preparation Batch. This has been started from November 4th. There's a capsule course for Judiciary Preparation Batch started from November 11th. There's a rapid revision judiciary batch which has been started from October 27. There's an extensive judicial preparation batch started from October 20th. This is the result from the Unacademy for Rajasthan Judicial Services examination. These are all the features of Unacademy iconic: live doubt solving, one-on-one live mentorship, focused test series, all the benefits of plus, and there are mock interview videos as well. So this is the YouTube and the Telegram channel of Unacademy, and that's it from my end. Ayush, capsule course works as a crash course. Okay. Thank you, G. Ladley. Thank you for the kind comments. That really means a lot. So see you in my next class. Till then, yes, it's time to say peace.